Lordship, this is a revision application against the order passed by the lower court, making me an accused in a 12-year-old case after the entire trial is almost over and last witness was being examined. Moreover, we are challenging that as well as the direction of the court.
What was application exhibit 294 and given by whom?
Pardon, sir?
What was application exhibit 294
Ji.
and given by whom?
This was given by the owner of the land, which was given as a mortgage to as a collateral security to a loan taken by the fraudsters. Now,
So
this
under 319 you were arraigned as an accused?
I was not an accused in FIR. I was not an accused in charge sheet. I was made an accused in 17. The charge sheet is
Pursuant to an application filed by the prosecution under section 319?
yes, sir.
All right.
Now the issue is the applicant has submitted a document which is fifth copy or tertiary copy of the original. They have not even produced the original, and this is like this, Millard. And based on this, can I be made an accused, which is an inadmissible document?
Read the impugn order.
And the learned honorable judge below has committed some errors in reading the whole story.
Read first read the impugn order, thereafter further whatever you want to argue, you may argue.
The notice which was given to us, order below the application on 294, says that, I will read the relevant portions. It also appears from the statement of Shri Rasik Jivabai Thakur under section 161 CRPC, and they said Shri Rasik Jivabai Thakur has given his statement before the CBI that the said land is belong to him and he has not sold it to any person. Now the issue is, this was known to CBI even at the time of filing the charge sheet, and the thing was also considered by the learned judge who has framed the charge sheet. Coming to the next, they said Rasikji Juhaji Thakur has deposed before this court that he has not sold out the said land to anybody, and they said Deepak Kantilal has falsely fabricated and prepared and registered the sale deed in his name. He has not signed anywhere before sub-register office at Kalol. Now the issue is this conclusion that the honorable judge is totally erroneous. Nowhere in his statement he said that it was done by Deepak Kantilal Shah. He simply said that I have not sold. This is the document based on which they have done some mischief. Nowhere he has named Deepak Kantilal Shah. In fact, when he was asked whether you know Deepak Kantilal Shah, he flatly refused, saying that I never met him, I don't know him.
No, he is examined before the court.
Yes, Millard.
Before court,
twice.
What he has said. Because you are not reading further part of that very paragraph.
I am reading. I will read the whole thing, and then I will come to the position. Yes. Considering the above factual aspects as well as CBI has narrated in the charge sheet at page number 2
Not
about
that the said Rasikji Juhaji Thakur has deposed before this court that he has not sold out the said land to anybody, and the said Deepak Kantilal Shah has falsely fabricated and prepared the register sale deed in his name, and he has not signed anywhere before the sub-register office at Kalol.
Yes,
it has come in evidence of this Rasikji Juhaji Thakur.
No, only thing that
show me that deposition.
Millard,
if what is recorded by the learned judge is incorrect,
because what
show
he
me
has
from
mentioned,
his evidence.
Yeah.
No.
He used the word koi.
In very paragraph 2 of his deposition, he says that
he doesn't say that it is done by Deepak Kantilal Shah.
No, no. He says that this sale deed stands in the name of Deepak Kantilal Shah.
It was a one-sided sale deed, my lord.
Mr. One-sided plus one-sided, two-sided, or 10-sided.
Yes.
Sale deed is in the name of Deepak Kantilal Shah.
Sir, the issue is we don't know the correct position because the copy produced is inadmissible and fifth copy.
You are Deepak Kantilal Shah?
Yes, my lord.
All right. This land stands in your name as on date?
No, no, my lord. It has already been sold by State
By whom?
Syndicate Bank.
By pursuant to what?
Pursuant to SARFAESI Act, it has already been sold.
Mr.
So-
that is why I'm asking you.
Yes, my lord.
SARFAESI Act, yes. But
Yes.
who took loan over that property?
One
Deepak
fraud.
Kantilal Shah?
No, my
He
lord.
was guarantor.
He is shown to have been guarantor. He is not the
And
guarantor.
he, as a guarantor, he produced this property.
No, my lord, he has
Mr.
not produced. That's what I'm saying.
You have to answer this.
Lordship, this whole loan has been granted on the basis of fake and forged documents right from chartered
Everything is based on fake and fabricated document.
right from chartered
Mr.
accountants statements to the last valuation report. The whole thing was fake.
Everything is fake. Even this property stands in your name. That document is also fake. You stood as guarantor.
I
as
have
claim-
not signed anywhere in any bank,
It
my
is
lord.
your defense, Mr.
Yes, my lord. That's
Is
what
it not your defense?
I have to tell my defense only, my
Yes.
lord.
Then that defense would be considered after the evidence is laid before the
But
court.
the problem is, my issue is whether the document which he has produced is admissible in law. This is fifth copy
Which-
and no original
That-
secondary or
that-
third.
That you argue in the case.
Lordship, second thing is there are,
On that background, where no revision can be entertained.
Lordship, there is one thing. There are judgments which clearly say that when no new evidence comes on record, I cannot be implicated as under 319.
Produce
Now-
the decision.
Yes, my lord.
This is the evidence on record, on oath. There is no question of new evidence.
Yes, my lord. So the evidence which was already produced in the court during trial
Mr.
is documentarily
It
available
has
with the
not
court.
taken shape of an evidence. Therefore, after it has taken shape of evidence, you have been indicted.
No, my lord.
This Rakesh Rasikji Juhaji Thakur is examined before the court or
Yes, my lord, but this document has already been taken during the examination of the bankers. The bankers have come already. They have deposed. At that time, it was already given an exhibition number.
Bankers are not concerned with Rasik Juhaji Thakur.
But the exhibit number was already there, my lord.
That doesn't mean that he is implicated in the case.
No, my lord. What I am saying is, once the banker have identified this document and a exhibit number has been given,
Bank
it's
said-
on record. It's an evidence on
All right.
record.
Whatever you want to argue, you finish off your argument.
Ji. One judgment is this, my lord.
Yes.
I have mentioned all the judgments in that, and I have mentioned the.
It is not reported by Mohit alias Sonu,
It is reported.
in which this. Why then you are producing this copy?
I am keeping one wife for my certificate.
You must produce the reported decision only.
Frankly speaking, my lord, the complainant who has produced this document himself is unreliable. He has argued that this land belongs to him. He filed the issue before the Mamlatdar against me, against the other people, and the Mamlatdar has turned down his application. Later on, he filed a civil appeal. Even that civil appeal was against him. The issue is the mother was selling separately, the son was selling separately, and they don't know who has sold to whom. And we don't know whom they have sold, and my name is brought on record saying that I am the accused. I have never visited Vienna. I have never visited any bank. I have never visited any place. The signatures in the records also are not confirmed either by me or by anybody witness or by handwriting experts or by any other person. There is no evidence against me, my lord.
You stood as a guarantor in what proceeding or what loan transaction? On behalf of whom? Who obtained loan where you stood as a guarantor?
Lordship, I won't say I stood as guarantor anywhere because I have never signed anywhere. But on paper, I am the guarantor of Mr. Kamlesh Patel. That fellow is absconding.
Kamlesh Patel. All right, you stood as a guarantor.
Ji.
All right. And in a guarantee, you have produced this property as a mortgage with the bank or only titles of the property?
The documents were also submitted by Kamlesh. That also is on record, sir.
That may be your defense. Right
no,
now,
not my defense, my lord. It's already on record in the evidence gathered from the court.
It is in your name or not?
Pardon, sir?
It is in your name or not?
It is being shown in my name.
All right.
The banker has very clearly stated.
Have you been served with any notice by the bank or no?
No, my lord.
Without ascertaining, you don't say no.
They have not given me any notice.
Mr. Kodekar.
Please, sir.
What is this whole case is?
Sir, page 17, not if my lord would please to see the order.
That is the order.
Yes.
I am talking about the case.
Yes.
What is the charge?
The case is not the case credit limit has been not granted.
Cash credit limit.
Yes.
CC limit.
To one Mr. Kamlesh Patel.
Kamlesh
Corporation. In the name of the Kamlesh Corporation. So that is the one account has been opened in the Bank of India, my lord. And the case credit loan has been not granted for some amount, that is 30 lakh and 25 lakhs, but under two heads. Now the branch manager has taken the collateral security. The one dot security has been the residential premises of in the name of Kamlesh Patel. Now that too was not on the basis of the bogus share certificate.
All right.
And the second lot, the equitable mortgage, which is not in the form of the piece of the land, in the name of Deepak Kantilal Shah.
This equitable mortgage is done by whom and with whom?
Deepak Kantilal Shah.
All right.
During the course of the investigation, it has been found that the said piece of land is belonged to Rasikji Juhaji Thakur.
Yes.
So the statement of Rasikji Juhaji Thakur was accorded by the CBI.
No, you just don't go on that Rasikji Juhaji right now. If this collateral security residential house of that branch manager and the Kamlesh Corporation,
Yes.
Then what bank has done? And as a security, this other piece of land was also
yes.
shown
There
in
are
the
two
equitable
security.
mortgage.
One is the residential premises of one Kamlesh
Patel and this
and another the piece of land in
right.
the name of Deepak.
Then what bank has done?
Yes.
Or the CBI has done?
Yes.
Lordship, I want to. Initially, when the loan was given, I was nowhere. The loan was disbursed. First, when the loan was disbursed, at that time there were only two guarantors. One was Kamlesh Patel, his property was collateral, and one Mr. Naimesh Patel, his brother or some cousin, whose property was also mortgaged. Then later on, when the bank has failed and the vigilance people started inquiry, at that time they called Kamlesh Patel again and asked him that this is bogus, that share certificate what he has submitted about the purchase of that house from the society. The society manager has given a statement that he's never been a member here. So that thing has been found to be fake and bogus. So you arrange for some other collateral. Now we say that Kamlesh Patel has forged these documents and produced, because even the bankers say that these documents are produced by Kamlesh Patel, not by us.
Yes.
so far the not piece of land is concerned, which is not appear to be in the name of Deepak Kantilal Shah.
Equitable mortgage is
Yes.
between whom? Bank and the.
Yes, bank. Yes,
It
that is
was
the, what
given
is the
in
function?
mortgage
Yes,
to the bank
yes, yes,
by the Deepak Kantilal Shah.
yes.
All right.
And the valuation report was obtained.
Valuation, I am not concerned right now.
Because it is also not the valuer is also not one of the co-accused. Now, valuer not gave.
I am concerned with the involvement of the Deepak Kantilal Shah. If property which stood in the name of Deepak Kantilal Shah may be on a forged document, after non-payment of this loan amount,
Yes.
what steps bank had taken against the original borrower, as also even this person who has mortgaged his property
Yes.
as a guarantee?
That might not be found in the charge sheet, not page 55.
Yes. What steps bank had taken?
Yes.
Had the bank issued any notice to Deepak Kantilal
In the
Shah,
moments, in the moments.
Kamlesh Patel?
But may I read not certain part of the charge sheet for my note? Page 55 note, somewhere in the middle. During review of the loan account, though this land was shown to have been owned by Sri Deepak K. Shah, however, it has been revealed during investigation that one Sri Rasiki Juhaji Thakur was the actual owner of the property. During review of the loan account of the accused firm, Messrs. Complaints Corporation, the then branch manager J.S. Rao had further obtained equitable mortgage of property owned by Messrs. Gujarat Fibrotic India on 23 Bejar Bay. However, this company was found to be non-functional and was a defunct company. Now,
it is third transaction.
Yes, third transaction.
I am on the issue of involvement of the present accused.
So
if you want to indict him, you have to show that.
Evidently, on the face of the record, it is found that Rasikji Juhaji Thakur has not sold away the piece of land to Deepak Kantilal Shah.
On what basis you came to conclusion that Deepak Kantilal Shah has forged these documents? Have you ascertained? Have you taken a
that is on the basis of the
handwritings or the signature of the Deepak Kantilal Shah, but for comparison?
No, that is on the basis of the
Have you examined this Deepak Kantilal Shah during the course of investigation?
No, Millard.
That is on the basis of the statement of the
Rasik Juhaji might have given name of Ratanlal Kodekar.
Yes,
then Ratanlal Kodekar would have been joined as an accused.
But that is why the investigation started.
What investigation you have performed? I am asking that only.
So the statement came to be recorded.
Of Deepak Kantilal Shah, any statement was ever recorded?
Rasikji Juhaji Thakur નું છે.
હા, એને શું કીધું કે મેં કોઈ દીપક કાંતિલાલ શાહને વેચી નથી. બરોબર? તો દીપક કાંતિલાલ શાહને શોધ્યો કે ના શોધ્યો?
Yes.
હા, પછી એનું સ્ટેટમેન્ટ લીધું કે નહીં?
એના માટે ચાર્જશીટના લિસ્ટમાં સર એક જ મિનિટ જોજો.
Sir, the title was verified by one of the leading lawyers of this.
That lawyer should have been prosecuted.
That he was brought on before court, and court said that no, he cannot be prosecuted because you cannot. They did not have any evidence that he has given a wrong title verification report. He had verified the title very correctly, and he has given his report as per the documents available there.
When during the course of loan transaction, it is found that it is based on a fake document. Is it not the duty of the even advocate when it was obtained after this all fraud came to light?
No, Millard. It was taken before. Before taking as a collateral, this land was got verified from a valuer as well as Mr. Maid, who is a very famous lawyer in this line, and he has given a very clear title clearance, and that fact stands because this bank also could easily sell it. Otherwise, bank would not have. This fellow did not raise any objection when the bank sold it. Then again, when the next party failed in its loan,
itself is illegal.
Which one, sir?
By the bank.
Bank manager is being prosecuted, Millard.
If that Rasikji, who is he? Rasikji Juhaji Thakur clearly says that he has not sold it to anyone.
Lordship, there is one more thing I'd say. The payment is made by check. Half of the payment is made by check. The other half is made by cash.
By check to whom? Rasikji Juhadi Thakur?
Naturally, he has to put his thumb impression. Two witnesses are there. They have not examined the witnesses. They have not examined Rasik, except for Rasik Juhabai. They did not call for the
What he
witnesses.
has said about this transaction by check to him?
The main issue is, sir, the land rates have increased, so they are disputing all these things again and again.
Mister, I am asking you in a statement what Rasikji has said when he is confronted with the payment by check for sale consideration.
He was never confronted, Millard. He was never confronted about the check. No investigation was
Mr.
done
Kodekar,
whatsoever
Yes, sir.
about it.
call your IO who has investigated
Yes, I
this
will call you.
and get the assistance.
Yes.
Real culprit you have not
And
reached
that is
to.
why 319, sir. That is why 319.
I will deal with that argument, Mister. For bringing him under 319, what is material with you?
Material not during the course of the trial, not it has been not come on the record.
Mister,
In the deposition of Rasikji
Sir,
Juhaji Thakur.
even during the course of investigation, it was revealed.
Yes,
Not a big
but no.
Yes.
The
If it is revealed, what you have done?
yes, that I will not
Then-
ascertain from the IO. Certainly, I will ascertain from the IO.
It was revealed in his statement of Rasikji Juhaji
Yes.
Thakur. If it is
Yes.
revealed, was it not your duty to examine that
Yes.
very person? Whether he is accused or
call-
not, it
I
is
will
a
call the
different
IO
thing.
and I'm not the.
He may have a different say also.
Yes, yes. Yes.
On the contrary, you have permitted the original accused to let go.
Too late go, yes.
You would have said that this Kamlesh or even bank manager may have done it.
Yes, yes.
You were required to even examine the signature, handwritings on the sale deed with everyone, including bank manager.
With due regards, my lord.
I will not, I will ascertain not from the not report of this.
This prima facie, it appears to be perfunctory, Mr.
No,
Yes,
actually,
investigation.
I'll explain this whole thing, my lord. I was an ex-CBI officer. At that time, there was a bulk of cases in the same branch. So there were 6, 7
Then they
cases.
should either resign from the CBI
No,
or
but-
ask for assistance of other officers. They can't say that bulk of cases, therefore, in a proper direction, I will not investigate.
So their main crux was about the bank's recovery. That was their main crux.
They are not
That's what
supposed to help for recovery. They are supposed to book the culprit, real culprit.
Yes, my lord. If they had done it, then we would have been not suffering today like this.
અને SCC નો equivalent citation સુધી પાછું આપી દો. કયું છે સાહેબ?
कौन सा दिया है? हरदीप सिंह वाला
मैंने
मंगल।
हरदीप सिंह का भी दिया है और वो गुड़िया का भी दिया है और किसका भी
ठीक।
दिया
Citation દો.
है। Sir, I have mentioned in my application.
7 789. When will you assist?
My lord is keeping on.
Next week?
Lordship, I suffer from heart problem as well as non-alcoholic liver cirrhosis. I came from Hyderabad only today for this thing. So could you kindly fix it somewhere in January? By the time that IO will also be found and brought here.
You also want to shield your ex-colleague?
No, not me. Not that. He would not be in
was
Ahmedabad
not-
by now. He would have
No.
gone somewhere, got 3 promotions, 4 promotions.
That is the very sorry state of affairs.
Sir,
Persons who has investigated the case is not easily available. Even court wants to dispose of the case, court is not able to do it. What is this going on?
Lordship, that IO was not examined before the court also.
He is
At
not
that stage
required to
had
be
not yet
examined, till the all witnesses are examined.
So either the date may be given
He is
somewhere
not
in
shown as
January.
either witness
Because
or a.
now the holding IO would be there only. Not original IO might have been retired also. Or if he's there, then he might have been transferred. But I will have to be ascertain from the
You
original
also
record
ascertain
from the
from the
Malkhan
charge sheet
upload.
whether Deepak Kantilal Saab was shown either as an accused
As an accused at
absconding
the time of
accused
the filing
or
of the
even a
charge sheet.
witness,
Yes, yes.
or what steps current at the relevant time, the IO. what
Yes, yes,
steps he had
I got
taken.
it. I got it.
Yes,
My lord, I have the charge sheet, I have the FIR, nowhere is mentioned,
his name is not there.
nowhere. Even while framing charges
If a
also,
witness states before you that this is not my signature, I had never sold any land to him. Was it not the duty of that IO to?
The duty of the IO to arrest not, that is they will not direct case
If
against.
not arrest, at least
Deepak
examine that
Kandilal,
man.
Yes.
His version may also be recorded.
Even under 160.
That either
he
he
may-
is telling lie.
Yes,
I had given him a consideration through check. That
I agree, my lord. I
check
totally agree with this one.
account in the name of Rasikji Juhaji Thakur must have been opened by forging documents. Either the Kamlesh Patel or this Deepak Kandilal
Deepak
Sahab must
Kandilal
have
Sahab.
opened that account and withdrawn that amount also after payment.
Yes.
So ostensible sale is shown in the favor of Deepak Kandilal Sahab by Rasikji Juhaji, who denies to have entered into any transaction. Was
Yes.
it not duty of the IO then to reach to the root of the case?
Yes, yes. He has to examine Deepak Kandilal.
Yes, I will write in
He
this
has to.
order. Prima facie, I am not convinced about his efforts.
Yes, yes, yes.
Lordship, one small thing I want to say. They forged so many documents, that Kamlesh Patel and his gang, that even blank signatures, these blank papers of guarantee, his signatures are appearing. Even this is from the CBI record only, that this is the copies we have been supplied with.
ये तो बद्दा blank paper मत सही हो ले लेते कोई भी transaction हो एमा.
This is, I am saying, but I have.
It is loan documents.
This is a
Blank papers
guarantor's
must be
guarantor
CBO,
signature, my lord. This
Even
is-
you will also sign in blank papers produced by the bank for the purpose of loan. Don't say
Maybe
that.
is.
Yes.
मैं housing loan लेती तो मैं भी
हाँ,
करी.
हाँ.
A blank, outright blank, my lord. And at that time, the procedure was only one-sided sale.
And
deed,
Kamlesh
that's what.
Patel is not booked yet. He is absconding.
The second thing is, my lord, one more submission I
Yes,
want to
yes,
make.
sir.
My lord, I want to make one more submission. I was one of the collateral, okay. Gujarat Fibrotech, one Mr. Rakesh B. Patel has signed there 10 times on behalf of this, and the bank manager say that he appeared before us and signed. Whereas in my case, they don't say. They say that we don't know him. He has never come to the bank. That fellow is not being involved as 319, and I am being hauled up, sir. That fellow has 11,000 acres of land, and I am being hauled up for something which is not even in my name.
There are different considerations, Mr.
I don't know.
Yes.
And that Rakesh Patel has signed without company's authorization, without the articles of association,
Don't
nothing.
worry, this will not be adjourned in January, Mr. Either you appear or ask someone else to appear on your behalf.
Sir, I have studied this thoroughly.
Then you have to be here, Mr. This is of 2017, because of which even trial is stayed.
Yes, ma'am.
Therefore, I will not permit this matter to further prolong.
December will be very difficult, my lord, because I have to undergo certain tests and things at
You
Hyderabad.
undergo that case, Mr. On the contrary, you are helping the existing accused
No, my lord.
by your.
I am convinced from my heart, as an officer of the court, I am saying I am convinced from my heart that this fellow is nowhere involved.
I am on the issue.
I will not stand up. See, sir, you have never seen me in the court. There is only few cases I come here in which I am personally convinced
All right.
that he has not done it.
You have
Sir.
misunderstood my statement.
No, my lord. I'm sorry.
By getting this matter adjourned in January, you are on the contrary helping the real accused who are being even prosecuted right now because of stay obtained in this case.
Problem is that fellow is already absconded.
No one is right now to be prosecuted.
No, only JS Rao is being prosecuted.
Who
The
is he?
branch manager.
Branch manager. Even if one is there, let it be prosecuted and
Then-
let the case come to its logical end.
Then my humble request is that this case may be separated and let them
No,
continue
I
with the
can't do
balance.
that.
Pardon?
I can't do that. And it is not here. For that, you have to
They
go
got
there.
below it.
No, let them separate that issue and let them continue with the trial, my lord. Because in this case, again,
It is not my botheration. I am concerned with this revision application right now.
sir, after that I will not speak, my lord. when this order was passed, the judge, the honorable judge there, he on his own passed an order, directed that only those witnesses related to you will be examined. And he started examining half of them, some of them. Now, there was no examination in chief. Mr. A. Sheikh, the senior PP at that time, was in Hajj. He was not even present in the court. Directly, we were asked to cross-examine. Of course, I was not there. There's some junior lawyer is fighting there. So that fellow was forced to start cross-examination. So we request that even if some order is passed, that thing should be set aside and the trial should be ordered right from beginning under 3194.
In this case, there is no stay granted by the court.
It is granted by the court.
Then how he has proceeded with the trial?
At that time, it was not there. So when he started doing all these illegal things, then I came to the revision, came under revision to these things. And then I started.
If you have already participated, how I
have not
why I should
participated.
undertake this exercise, Mr. You have cross-examined certain witnesses also.
I have challenged his action also.
It is subsequently.
Yes, my lord. Because he was doing illegal trial.
Where is the question of illegal trial, Mr.
Because 3194 clearly says that in case I am added separately, then the whole trial should start afresh with examination, cross-examination and everything. Please.
Not afresh. You have to cross-examine whatever the witness is already examined.
No, my lord.
They can't be again examined afresh.
Kindly see the 319. The wording used is examined, cross-examined and
they are already examined in chief. Have you
Lordship,
any grievance against that by examination?
Yes, it was not recorded before us. The examination in chief, whatever had happened, it was not before us. It was done behind our back.
That doesn't mean that it is incorrect.
Maybe, my lord, at that time, if I was present, I would have taken some more points. That what mistake he had done, and I would have cross-examined there itself and demolished him there.
That is not the idea. Anyway, Mr. Kudekar, you call your IO.
Yes, my lord is keeping on.
In the first week of December,
Please,
8th December,
instead of 8, not 9 or 12.
9th December.
Please.
Lordship, I once again submit that it may kindly be shifted to January. Because I am really very bad condition. I am coming after 2 months of, 2 times I have been admitted in Apollo here. Then these people could not do so. I have gone to Hyderabad and
You are
getting treatment. I am SS Sastry, Milan.
Mr. Sastry, learned advocate for the petitioner.
Last time also I had requested
6th
Kodekar
time.
sir.
In the month of January, as he is not keeping well and he has undergone, he was hospitalized and having heart problem.
And liver cirrhosis, Milan. And liver cirrhosis.
And non-alcoholic liver cirrhosis also. At his request, SO2. January मुझे तारीख जो
Thank you. Thank you, Milan. Obliged.
2023. Mr. Kudekar, you just have the material with you. Call
Yes.
IO and get ready yourself to argue this matter.
Ji.
So that again it may not have to be adjourned as and when it comes up for hearing before this court or any other court.
Please, sir.
You just concentrate for prosecuting this man. What is the material with you?
Yes, yes.
Whatever material you are saying that was already there at the time of investigation, then you are supposed to answer what investigation you had done
Yes,
at the relevant time.
yes, yes.
You can't non-suit him at this stage without investigation.
Yes, yes.